Went to Osgood Hall until 1959, graduating and admitted to the Ontario Bar in that year. He is now a partner and practices as a partner of Rachlin and Wolfson in Toronto. Ted is presently a member of the Board of Governors of the American Trial Lawyers Association of Canada. He's a former president of the Advocate Society, just completing his office. He was a member of the Chief Justice's Committee on Tort Compensation, a special committee of the bench and bar to consider the feasibility of periodic payments of judgments and the variation of adjustments. He's a fellow of the Foundation of Legal Research. He still instructs here in Osgood Hall in civil procedure in the bar admission course and has done so since 1967. He's a member of the faculty of the National College of Advocacy of the University of Nevada. He very often is called upon to speak in special lectures for the Law Society. He's been the author of many published articles in the field of tort, and he was a valuable member of the planning committee for this series of lectures, and it's a great pleasure to introduce you to him. Ted?
Thank you, Bruce. As we know, and as Tom Lambert illustrated so vividly this morning, there are many ways in which American tort law is more responsive to societal change than tort law in this country or in this province. But there are some areas in which we're ahead, and it's about one of those areas that I'm going to speak today. It's an area in which we're way ahead in Ontario. March 31st of 1978 was a very important day in the history of tort law in this province. On that day, the Family Law Reform Act came into force. As all of you know, that is an act that made radical changes in the relationships of family members among themselves. But in the case of wrongful injury or death of a person, it also created tort rights in family members far beyond those that the law had previously known. It was legislation unique in the common law world, and it created more tort rights than any statute since Lord Campbell's Act in 1846. We've had the new legislation with us for 5 years, and its effect is just beginning to be felt. Lawyers and judges are becoming more comfortable with it, and the next few years will see actions by family members reach their full maturation. Now, what can be claimed under the Act? Let me talk about what the situation was before the Act. Before the Act, family members of an injured person had certain limited rights against a tortfeasor. A husband had, in some cases, a claim for loss of consortium when his wife was injured, but a wife didn't have a similar claim. Some American courts gave a wife a claim. Indeed, some of them recently have given rights to a child to claim for loss of consortium of a parent. Tom Lambert mentioned this morning about a decision of the Massachusetts Supreme Court which held that. What he didn't say is what he's said so often before about the Massachusetts Supreme Court. He's previously described that as a court so conservative that it wouldn't look at the new moon out of loyalty to the old. And I see that it's changed somewhat. At common law, in this province, a child had no right to claim for injuries to a parent. A parent did have a claim for the loss of services of a child. A husband could sue for expenses incurred on behalf of his wife, and a parent could sue for expenses incurred on behalf of an injured child. The injured person had the right to claim for the value of services performed for him by a family member. At common law, a survivor had no claim for the death of a person. This was remedied somewhat by the Fatal Accidents Act, with which you're all familiar. That gave family members a right to claim damages as a result of a wrongful death. But the courts restricted that claim to pecuniary loss. although the concept of pecuniary loss was extended to include the loss of a parent's care and guidance. Now, the Family Law Reform Act abolishes the right of a married person to sue for loss of consortium, and it abolishes the right of a parent to sue for loss of the services of a child. It repeals the Fatal Accidents Act. It takes all this away. But all of the rights that it takes away are replaced by the Act, and it increases those rights greatly and broadens the class of family members who can make claims. The Act provides that where a person is injured or killed by the fault or neglect of another, under circumstances where the person is entitled to recover damages or would have been entitled to have recovered damages if not killed, certain family members are entitled to recover from the tortfeasor their pecuniary loss resulting from the injury or death. Section 60, subsection 2 of the Act goes on to say that the damages recoverable, these pecuniary losses, may include the actual out-of-pocket expenses reasonably incurred for the benefit of the injured person, a reasonable allowance for travel expenses actually incurred in visiting the injured person during his treatment or recovery, where as a result of the injury the claimant provides nursing, housekeeping, or other services for the injured person, a reasonable allowance for loss of income or the value of the services, and an amount to compensate for the loss of guidance, care, and companionship that the claimant might reasonably have expected to receive from the injured person if the injury had not occurred. So we have a blanket entitlement to recover pecuniary loss, along with certain specifics. The allowances for the losses itemized in the first three categories, which I read to you, must be reasonable. That word doesn't appear in subsection 1 that refers to pecuniary losses generally, but no doubt it will be implied by the court. No doubt the principle of remoteness will also apply. It would seem that all reasonable pecuniary losses of all types are recoverable, subject only to their not being too remote. The inclusions in subsection 2 are generous. For example, expenses for traveling for family members to visit the injured person. They set a standard which will probably result in a reluctance to find claims too remote. The concept of pecuniary loss in its usual connotation doesn't present difficulty to any of us in interpretation, nor does the broadening contained in the first three categories of subsection 2. It's the last category, D part of subsection 2, which has presented a problem. That's the subsection that speaks of an amount to compensate for loss of guidance, care, and companionship that might reasonably have expected to have been received from the injured person if the injury had not occurred. It doesn't say anything about death. It refers only to injury. Yet the heads of damage that it describes are appropriate in the case of death as they're appropriate in the case of injury. And indeed, by judicial interpretation of the Fatal Accidents Act, as I said a moment ago, loss of guidance and care were compensable in the case of death, at least insofar as certain claimants were concerned. The question, therefore, has arisen as to whether this provision is restricted to injury claims only or whether it includes death claims. Another question has been whether the loss of guidance, care, and companionship must be a pecuniary loss to be compensable, because you'll recall the general provision in subsection 1 refers to pecuniary loss. By its very nature, loss of guidance, care, and companionship would seem to not be of a pecuniary nature. Now, one or both of these questions were considered by a series of Supreme Court trial decisions in Ontario. Let me turn to the Mason and Peters case, where the trial judge, Mr. Justice Hollingworth, held that injured person in subsection D included persons who are injured and then die. Then in the Thornborough and McKinnon case, Mr. Justice Linden described death as the ultimate injury, and he held as well that subsection D, the one relating to care, guidance, and companionship, applied to fatal injury cases as well as non-fatal injuries. And in the course of a very lucid examination of the effect of the new legislation, Justice Linden said this: "It would be an absurd interpretation of the statute to hold that there should be compensation for loss of guidance, care, and companionship if someone were injured and spent a few weeks in the hospital, but not if that person were killed and his relatives were deprived of his guidance, care, and companionship forever." He also went on to say that all of the items in subsection 2 are recoverable whether they're strictly classifiable as pecuniary loss or not. Several other cases were soon after decided, in all of which the judges held that subsection D applied to death cases as well as injury cases. And then came Hutchison and Harcourt, where Mr. Justice Steele accepted that subsection D applied in death cases, but felt that there should be no award for loss of companionship unless a pecuniary loss were found. He felt constrained by authority, though, to award a nominal amount for loss of companionship, and he defined a nominal amount as being $1. Well, the general movement was towards a broad interpretation of this provision, and that reached its peak when Mason and Peters went to the Court of Appeal. In that case, Mr. Justice Robbins, speaking for the court, gave a comprehensive history of the development of the law relating to wrongful death claims and concluded that the statutory provision allowing damages for loss of guidance, care, and companionship applies to death claims as well as injury claims, notwithstanding the unfortunate wording of the provision. So that would seem to be settled in Ontario now. Now, as to whether the loss of guidance, care, and companionship must be pecuniary to be compensable, Justice Robbins held that, again, notwithstanding the unfortunate wording of the statute, it need not be. He said that in enacting subsection 2 of section D, the legislature intended to extend the measure of damages by permitting recovery for loss of guidance, care, and companionship on a non-pecuniary basis. And he rationalized that in a way that you will see from the printed paper to explain the inconsistency with the opening words of the section that refer to pecuniary losses. The conclusion might have been come to on the simple basis that, in fact, a loss of guidance, care, and companionship, certainly a loss of companionship, is non-pecuniary in its nature. And the legislature, by enacting that section, indicated simply that it was time to do away with the judicial fiction that built up over the years that said that loss of guidance and care in a fatal case were pecuniary because the cases said the only losses that were compensable were pecuniary losses. So we have the situation now that in both injury and death cases, family members can claim not only their pecuniary loss, as defined in a rather extended way, but also damages for loss of guidance, care, and companionship. In virtually every case, there's going to be at least a loss of companionship. It may be small, it may be large, but it will be there, and it's compensable. There will be new potential claimants in almost all injury cases, and damages in death cases will be higher than previously. There's clearly no award still in a death case for grief, but there will often be a very fine line between what is grief and what is loss of companionship, and that line will be even finer, I'm afraid, in jury cases. The Act provides that where the action is brought as a result of a death, in addition to the losses already discussed, damages may be awarded for the reasonable expenses actually incurred for burial. You'll recall that under the Fatal Accidents Act, there was a limit of $800. That limit has been removed. Now, all burial expenses are recoverable so long as they are reasonable. Often a family relationship begets a business relationship. Brothers become business partners, as do husbands and wives, parents and children, other family members. The death or injury of a business partner family member can cause direct financial loss to a partner. When that partner is a family member, the question arises as to whether the business loss is recoverable under the Family Law Reform Act or whether it's just the family loss. It's been held that it's the familial relationship which is intended to be protected under Section 60 rather than a business relationship, so the damages awarded to a business partner family member are restricted to what he's lost in his capacity as a family member rather than in his capacity as a business partner. I wonder about the correctness of this. There's nothing in Section 60 of the Act to restrict compensable loss to that which is of a non-business nature, and there'd seem to be room to argue whether or not these decisions are indeed correct. Perhaps the high watermark illustrative case would be that involving the death of a husband who was a business partner with his wife. One would think it to be clear that the wife's damages would reflect her business loss flowing from the death of her husband, as well as the losses that came to her in her capacity as only a wife. If this is correct, then it's hard to see why lesser family business relationships should be compensated on a different basis. Now, I've spoken about what can be claimed. The next question is, who can make a claim? Part 5 of the Family Law Reform Act, which deals with these claims, is headed Dependent's Claim for Damages. But this is a misnomer. A claimant need not be a dependent, so do not be confused by that heading. Section 60, subsection 1, enumerates those entitled to claim as the spouse, children, grandchildren, parents, grandparents, brothers and sisters of the injured or killed person. A very broad category indeed. Spouse is given the same extended definition as in the case of support obligations under the Act, and it includes a common law spouse under certain circumstances. The definition is such that a person can quite easily have two spouses, so that you can encounter a situation where there are two spouses, each entitled to make a claim under the Act, strange though that may seem. Those who fit within the other categories of enumerated claimants are not defined in Section 60, but child and parent are defined elsewhere in the Act, and those definitions apply to Part 5 that we're concerned with. Child includes a person whom the parent has demonstrated a settled intention to treat as a child of his or her family, and parent is defined to include a person who has demonstrated a settled intention to treat a child as a child of his or her family, similar to the old local parentis definition that was in the Fatal Accidents Act. Now, the category of sister was given an extended meaning in the case of Wessel versus Kinsman Club. A young boy was killed, and the claimants included a sister, Carla, to whom the boy's mother was legal guardian, and who was treated by all as the mother's child and the boy's sister, though there was no legal relationship between the boy and Carla. Justice Walsh considered that the circumstances were such that Carla would be considered a child of the parents in the event that she or one of them had been injured or killed, and he accordingly held that she came within the word sister in this context. The injured person cannot himself claim on behalf of his family members. The claim must be asserted directly in an action commenced by at least one of the statutory beneficiaries. It can be joined in the same action as the injured person has brought, with simply two plaintiffs, one being the injured plaintiff, the other plaintiff being a family member suing on behalf of the category of family members entitled to claim. On the other hand, a family member can commence an action on behalf of all family members, and that action can be tried together with the action brought by the injured person. Obviously, the simplest and cleanest and easiest way to do it is to put them both in the same action to begin with. The Act hasn't abolished the common law right of an injured person to claim for the value of services rendered to him by a family member, or for that matter, by someone else. So don't overlook that. There may be circumstances where you want to have the injured person claim for services rendered to him by somebody else, and that can still be done if there's a reason why you don't want to bring a Family Law Reform Act action on behalf of family members directly. A plaintiff commencing an action on behalf of family members must, in his statement of claim, name and join the claim of any other person who's entitled to maintain an action. And the Act provides that thereupon such person becomes a party to the action. There's no need for the other family members to be plaintiffs. By simply naming them in the statement of claim, they become automatically parties to the action. Because these people become parties to the action, they're subject to discovery, even though they don't appear in the style of cause. And if the claim of a family member is dismissed, it would seem that he could be liable to the defendant for any costs to which the defendant may be entitled by reason of that claim being dismissed. So that care should be taken to not indiscriminately add the names of people as family member claimants, unless you're satisfied that they do have a claim of sufficient significance to warrant the trouble and to warrant the discovery and to warrant the potential costs exposure. Where a claimant includes an infant, bear in mind that any settlement of that infant's claim must have the approval of the court, just the same as if the infant were named as a plaintiff in the style of cause. When settling an injury claim for at or near its policy limit, an insurer has to be wary of Family Law Reform Act claims. No longer is the concern only with the injured person, but there may be other people out in the woods who will be making claims, and if there's not going to be enough money to go around, the insurer has to be careful not to pay too much of it out on one claim for fear of there being a shortfall. If, however, there is an action brought on behalf of family members, and if it's settled, the insurer ought not to have to worry about any other actions being later brought, because the Act provides that there can be just one family member action. So having settled that action, you've settled all of them. Because there can be only one family member action, there can be difficulties where there are family members who don't get along, or where there are limited funds available and they can't or may not be able to agree as to how those funds should be divided amongst themselves. In a case of Duffin versus Mahagan, District Court Judge Fitzgerald was confronted with this, and he held that if the circumstances require it, each claimant is entitled to separate representation in the one action, is entitled to deliver a separate statement of claim for damages, and to participate in the discovery of the defendant and at trial. He left it to the trial judge to decide whether one family member could, at trial, cross-examine another family member claimant with respect to damages. There are a series of troublesome cases holding that family members can make claims under the Act after the 2-year limitation period set out in the Act, or after another applicable limitation period has expired. In Casey versus Halton Board of Education, an action was brought on behalf of an injured infant plaintiff by his father as next friend. it's important that the father was as well included as a plaintiff to assert a claim for the lost income due to his son's injuries. After the expiry of 2 limitation periods, an application was made for an amendment to the statement of claim to make claims under the Family Law Reform Act on behalf of the father, the mother, and the sister. Justice Krever held that although it may not have been expressly so pleaded, the action commenced by the father was really to recover losses contemplated by the Family Law Reform Act, and all of the facts with respect to the tort alleged had been pleaded. He said that the defendant had throughout been aware of the case it had to meet, that being the negligence involved in the tort claim of the injured plaintiff, and the amendment sought not to change the case the defendant had to meet or create a new cause of action, but it merely related to a new head of damages for the family members arising out of the same factual situation pleaded in the original statement of claim. He accordingly held that the amendment was proper and permitted these claims to be added. In dicta in Campbell versus Carrier, District Court Judge Fitzgerald indicated as well that provided an action on behalf of family members was commenced within the limitation period, additional claimants could be added after the limitation period had expired. Those cases don't go too far. There was already in each of them a plaintiff making a claim that was either under the Family Law Reform Act or deemed to be under it. But in the case of Brar versus Hewitt, a new plaintiff was allowed to be added after the expiry of the limitation period. In that case, a woman was injured while she was a passenger in her husband's car. She commenced an action to recover damages for her injuries. After the expiry of the limitation periods in the Family Law Reform Act and the Highway Traffic Act, she applied to add her husband as a plaintiff to make a claim under the Family Law Reform Act by reason of her injuries, and also to make a claim on his behalf for damage to his motor vehicle. So she applied to bring him in not only for the family law claim, but to claim for the damage to the car. This was dealt with by Justice Southey on appeal from a county court judge. He felt that the judge was right in permitting the husband to be added as a plaintiff, even though he considered that the claims asserted by the husband involved new causes of action. On the same day that he made that decision, there was a county court decision being made by Judge Flynn in the county court of the County of Middlesex. That was Vassiliou versus Liston. Judge Flynn was influenced by the fact that under the Family Law Reform Act, only one action lies, and as the existing writ was issued well within time, he granted leave to add the injured man's wife as a plaintiff to assert claims on behalf of family members. Of course, that one action that he referred to is one Family Law Reform Act action, and the one action that was pending was not a Family Law Reform Act action, but an ordinary action by the injured person. In another case, Judah versus Patterson, a wife was also added after the expiry of the limitation periods to make FLRA claims. The statement of claim, which had been delivered within the limitation periods, alleged that the plaintiff had undergone a personality change, which had adversely affected his married life, and the marital consortium had been affected. Justice Osler, in upholding the order of a county court judge adding the wife as a plaintiff, was persuaded that this did not constitute recognition of a new cause of action, as the wife's claim arose entirely from the existence of the factual situation described in the writ and statement of claim. I personally have considerable difficulty with these cases. The principles to be derived from them are not clear. They seem to conflict with the general law that says, other than in very exceptional circumstances, once a limitation period has passed, a plaintiff cannot be issued. It cannot be added. Presumably, before long, we'll have an appellate decision which will clarify this for us. At the moment, I suggest that the law is not in a particularly satisfactory form. Now, I've discussed what can be claimed and who can make the claim, and the question now is, how much will be awarded. Actual expenses incurred will be allowed, provided they're reasonable under the circumstances. Some examples. Where two people came from India to visit their unconscious sister, their traveling expenses were disallowed on the ground that it was unreasonable for them to come such a long distance in the circumstances. The injured woman died, and her husband and child returned to India with her ashes to immerse them in the Ganges River in accordance with custom of their religion. Traveling expenses in this connection were allowed as part of the reasonable expenses of burial. A child's expenses in traveling thousands of miles to his father's funeral, a wife's expenses dealing with personal correspondence of sympathy and condolence on her husband's death, and traveling expenses to make arrangements for the administration of the estate of the deceased were all allowed. Expenses of brothers and sisters of a deceased person traveling from Italy to Canada to attend the funeral were allowed. In assessing damages, similar to the provision in the old Fatal Accidents Act, the court is not to take into account any sum paid or payable as a result of the death or injury under a contract of insurance. If a deceased family member is or may be replaced, the damages of the survivors can be reduced. It's long been the law of Ontario that in assessing the damages of a surviving spouse in a death case, the fact or possibility of remarriage is to be taken into account, although the burden is on the defendant to prove the advantages to be derived from the remarriage. Similarly, it's been held that the acquisition of a step-parent can mitigate the loss of a parent. It's not easy to reconcile this with the general principle that collateral benefits received by a victim do not reduce a tortfeasor's liability. You're all aware of the Borelli and Flanagan decision in the Court of Appeal, which held that. This principle would seem to conflict with that. It's interesting, perhaps, that in England, there's legislation providing that remarriage or prospective remarriage is not to be taken into account, and this is the law in almost all of the American states. However, the law seems well settled here in the Supreme Court of Canada, and probably any change requires legislation to bring it about. Obviously, the most controversial and far-reaching of the new damages under the Family Law Reform Act are those under the heading of loss of guidance, care, and companionship. In Mason and Peters, a case involving the death of a child, the trial judge accepted that the new legislation substantially increased damages in such cases. In Thornborough versus McKinnon, Justice Linden, as I mentioned before, took a very liberal approach, and he saw the new head of damages as making a radical change in damage assessments. He made a comprehensive analysis of the scope of the words guidance, care, and companionship. And as to companionship, perhaps the broadest of the concepts, he said this, which I think is very illustrative. The companionship of parent and child is a truly unique pleasure. The joy of sharing experiences with one's child is hard to surpass, whether it be sports, culture, conversation, or play. There are not many activities more enjoyable for a parent than to participate with one's child in the celebration of birthdays, graduations, weddings, the births of grandchildren, and all of the other landmark events in their lives. What greater joy is there than to be with one's child on religious holidays, such as Christmas or Easter or Hanukkah? What could be a greater pleasure than to accompany one's child to a movie, a circus, or a hockey game? What can be more marvelous than to hear one's child laugh, to cuddle it before bed, or to watch it play with a dog? To see the enthusiasm for life in one's children often helps to restore one's own faltering commitment to a better world. Yes, companionship with one's child is one of the most prized of human experiences. To lose that is one of life's greatest losses. It was to provide compensation for that loss of companionship that the Ontario legislature inserted that language into the Family Law Reform Act. It was not meant to be treated as a trivial loss, for it is not. And he went on to say this: "The same things that I said in relation to the loss of a child apply in assessing the damages resulting from the loss of guidance, care, and companionship of a father and husband. Just as the court should give these words a liberal construction in fatality cases, the court should do so in non-fatality cases. These are not trivial losses, and the legislature did not mean them to be treated as trivial losses." Strong language, emotional language, very useful language, I think, in determining where we're going with this head of damages. Now, other judges have taken a similar approach, but it would not be fair if I were not to tell you that there are yet other judges who have seen the legislation differently. In the case of Zick versus High, Justice John Holland made the comment that a reading of Section 60 cries out for the exercise of judicial restraint in the general interest of the public in the assessment of damages consequent upon an injury to another, as in this case. I say this because, uncontrolled by such restraint, the ceiling under the heading of loss of guidance, care, and companionship for an award could be unlimited. And this conservatism carried over to Hutchison and Harcourt, where Justice Steele took a rather restrictive approach. He felt that to a great extent, loss of companionship is an emotional loss similar to grief and can't be properly quantified in dollars. It was his opinion that in the absence of proof of pecuniary loss, only a nominal amount should be awarded. And as I mentioned before, he considered a nominal amount to be $1. So we had this divergence of opinion. When Mason and Peters got to the Court of Appeal, that divergence was to a very great extent resolved. That was the case of the wrongful death of an 11-year-old boy whose paraplegic, permanently separated mother was greatly dependent upon him. The trial judge awarded $45,000 to the mother and $5,000 to the 10-year-old sister, much more than had ever before been awarded for the death of a child. On appeal, Justice Robbins, speaking for the court, said this in dealing with the death of a child: "The most significant loss suffered, apart from the sorrow, grief, and anguish that always ensues from such deaths, is not potential economic gain, but deprivation of the society, comfort, and protection which might reasonably be expected had the child lived. In short, the loss of the rewards of association which flow from the family relationship and are summarized in the word companionship." And he said that this represents an important step forward in cases involving the wrongful death of minor children. Pecuniary loss concepts have proven excessively restrictive in these cases and have produced awards wholly incommensurate with the true loss sustained by a child's death. By expanding the measure of damages to include non-pecuniary elements of loss, the Family Law Reform Act recognizes the child as an integral part of the family unit, not simply as a potential source of future service or monetary gain, and provides an effective basis for more realistic and just damages than those awarded under the Fatal Accidents Act for tortious violations of this family relationship. And the trial judgment was affirmed. What was particularly important, I think, is that Mr. Justice Robbins said that apart from any pecuniary loss there might have been, and this is a case where you could have made perhaps a good argument for pecuniary loss because of the very great disability of the mother. He said that apart from any pecuniary loss there might have been, there was no ground of complaint against a non-pecuniary award to the mother of $45,000. So from this, it appears that the Court of Appeal regards the non-pecuniary loss of guidance, care, and companionship to be substantial, and it will award and support substantial awards for those losses, if, of course, the evidence justifies them. The influence of the Court of Appeal decision was perhaps felt in a recent case of Iwanishan versus Turk. That was the case of a wrongful death of a 5-year-old boy. And District Court Judge Fitzgerald, who has, as you will have seen, had a considerable involvement in these cases already, as it happens, was considering an award to his 6-year-old brother, the 6-year-old brother of the 5-year-old deceased boy. And he said this: "The companionship of a younger brother, close in age, is of substantial value, particularly where the relationship is close. There would have been advantages to the boys in facing life's encounters together. There would have been the element of joint consultation and mutual protection, as well as the social advantage of learning to share their experiences and possessions. The evidence discloses that this type of relationship between the brothers had already developed. The catalog of advantages to the two boys is really endless. David is now deprived of those experiences and advantages which he would probably have enjoyed for many years. For medical reasons, he will not likely have another brother or sister, and never one as close as the one he had. In my view, this is a substantial loss of companionship requiring substantial relief. And he awarded $8,500 to the brother. Now, the amount that will be awarded for loss of care, guidance, and companionship has to obviously depend upon the facts of the particular case. It has to depend upon the evidence that you call as counsel. The nature and quality of the relationship between the claimant and the injured or killed person and the period of time over which the loss is incurred are controlling. It's clear, however, that as the concepts of the new damages are being developed, and as lawyers and judges are gaining a better appreciation of their scope, awards are rising, and I think they're going to continue to rise, but on a step-by-step basis. So much for a relatively short overview of the new legislation. It's progressive, it's wide-ranging, and it's going to redistribute a lot of money. It's already made significant changes in damage awards in personal injury cases, and I think that what we have seen thus far is just the tip of the iceberg. Thank you.